going to share my screen. I'm sharing a presentation. So this is the story of a very short version and my own version of Mr. Uzoamaka. He's a Nigerian-born scientist, and he came to the US. He furthered his education. I think he got sponsored for master's. But I've heard of him from the community here in San Francisco, that there's this man that has over 70 patents. So I met him at a party and he told me his name. I'm like, you're the one. I heard you have 70 patents. He said, actually, I have more than 70. I said, how many do you have? He said, I will send you to Google or some ideas.com to check. And he had so many patents. It was like 350 on ideas or much more than that now. I said, how come one person has so many patents? And I told him, you must be very rich. He said, no, I trained in Nigeria. I came to the US. I got a job. And he started making his invention, the utility patent. I said, if you have so many patents, 350 plus, you must be a rich man. He laughed and said, no, I'm not a rich man. So I said, how come you're not a rich man? He said, because all the patents, I think all he said, or most of the patents are actually in the company's name, the companies that I work for. I am like, how come? How did that happen? So again, I took that as a lessons learned. And I'm like, we need to share this information. Are you a parent? Are you wondering why and how should I care about intellectual property? And he sent me to this ideas.com. He says, go and check and compare. Check for your name. Check for this person's name. This is a link that we'll share as part of the resource. So you can also check your family name and see who has patents and how many patents are registered in your name. We also compared for different countries and see that, okay, which countries in Africa have patents registered? We actually have patents registered in Africa. Compare Nigeria to the European countries. But we want to run this study. We want to run this awareness at minimum that you will understand what intellectual property is. What are my brands? What are my ideas? Why should I care about them? We don't want to continue losing creative ideas and innovations to the Western world because we did not know. So we come to this Western world and we find out, oh, there are patents, but it's too late. You've already signed the contract that whatever you discover, as long as you're an employee of this company, you will have your name on it, but you don't get the royalties necessarily because the company owns it and your name is just on it. I am not an expert in patents, but I felt compelled to definitely share the story and bring more awareness to people to know at minimum that there's something called intellectual property, and we could be the people who actually own the intellectual property. So again, the message he gave me as a takeaway was, and I will go into this more, is the first person to file gets the innovator label. You can't say, oh, but I thought about it first. Nobody knows that. So I will stop sharing and feel free to have your questions placed in the chat. We have a lot of questions that were submitted beforehand. And I'll let you go through some of your slides and then we'll go. Let me introduce and bring you our speaker for today. And his name is Ikechukwu. And we're so excited to have you on board today. Let me say a little bit about you. For today, you are the intellectual property expert. I am just the moderator. By the way, if anybody is wondering who I am, my name is Olabisi Adekoya. I'm the founder for VOA, Values of Affordable Education, where we believe that education elevates. So this is why we're bringing to you lessons learned, seasoned experts to get the conversations going, because we no longer want to be saying, but I didn't know. What we don't know can cost us. So I hope this message is very beneficial. And you have a takeaway and get the conversation going. So Ike has 5 years of experience in intellectual property, and Ike will tell us a little bit how he stumbled into this specialty to start with. He specializes in the global brand protection, meaning he catches the fake fake product online and in many spaces. And his role in intellectual property started as a paralegal and an IP manager. His focus is in safeguarding brand integrity. So you're a fashion designer, and even a tech person or female or an artist, how can you protect your integrity? So currently he serves as a legal program manager with a technology manufacturer, and he oversees a variety of legal projects, including those involving intellectual property. That's the short bio. So help me welcome Ike to the mic so that he can tell us through what we need to know much more about intellectual property. What is intellectual property and why should we care? How does it concern us, please? Mike.
Well, thank you. Thank you for that introduction. Piggying back off that. So at one point in time, I thought that I was going to be an attorney, and that I realized shortly after that that was not going to be the case, just based out of interest and things that I wanted to do. So I was hired by a global streetwear company as their IP paralegal. And in that role, I was supporting the attorneys on brand enforcement work, trademark filing for our brand logo in various classes. And from that, it spurred into me becoming one of the brand enforcement managers, to where I was focusing on offline and online investigations when it came to our product, engaging with government officials, different law firms across the world, in their IP practices to help best serve us. So my 5 years was spent in a mix of the legal, business, and investigation side of things, which gave me pretty unique insight into intellectual property, why it's so important, and also a realization of how little just the everyday person knew about intellectual property. At my current role now, I'm a legal program manager at a technology manufacturing company. And in that, of course, there are collaborations with various types of companies in different industries. So a lot of IP goes into that as well. So I've really, for the past, now it would be 7 years, have been really passionate about this topic. It's something that I find to be very important, especially in today's day and age where it's so easy to put out your works of art. It's a lot easier to collaborate with businesses, collaborate with other individuals. And with all of this, intellectual property is very important because that determines your value and also determines your leverage as well. And I have, will we be going into the slides now?
Yes, I think so. Do we have any questions so far? If not, I can pull up some of the questions that that were submitted. And of course, you go into your slides and tell us about it. People ask, when should they know that their idea is worth patenting? But I'm going to let you go into what kinds of intellectual properties, what they are and what it is, please.
Okay. So my experience is mainly in the trademarking and copywriting space. When it comes to patents, that falls under your inventions. So when should you know to patent your idea? Immediately, really. IP is one of the first things that you should consider with any business that you're engaging in. So if you have an idea of, let's say, recreating an engine block to where it makes the engine is more fuel efficient, or you're able to use a different source of energy to fuel a device. Things like that would be stuff that you would patent. And that's where you want to immediately consult an attorney on that for them to walk you through the process on getting this patented. A lot of the consultations are initially free, but all attorneys, they charge for their services. So at some point you will be charged for that service, but the initial conversation is always free, and planning for your IP protections is free as well. Coming up with that strategy on, okay, this is what I'm thinking of doing. This is the industry that my invention would be operating in. What industry could my invention potentially operate in? These are the questions that you want to ask. So you're prepared to put in your first registration, but then you're also preparing for those secondary registrations, which become key, because you can have one patent idea that is able to spur into 4 or 5 other patents, depending on what it is that you're doing. So you want to have a strategy that allows you to forecast for that, and just be prepared for the costs associated with that, the paperwork associated with that, the laws and the jurisdictions, the laws for the jurisdictions that you plan on that invention operating in. And this is where like an attorney really comes into play, with being able to break down that information for you and kind of guide you through the process. But you want to have some familiarity with the process before now having someone else come to you and tell you what the process is. So if there are questions that you have, you're able to ask those questions on the specifics, as opposed to asking questions on more generalized information that you would have already acquired.
Okay, thank you for that. I think it's a good place to go into your slides at this point. That's right.
Okay.
Thank you.
And can you see my screen properly?
Yes, I can. It's good.
Okay. So an introduction to intellectual property. What is intellectual property? So intellectual property, these are really just the creations of your mind. If you can think it, it's your IP. Whether you can protect it or not, we'll get into that a little later. But essentially, all of IP is what you create. Why IP is so important? These are just IP protections are so important. These are just 3 points that I brought up, but there are tons of reasons why it's important. Protecting the creator. This is extremely important because you want to know that the work that you put in your sweat equity in, your energy, your money, your time into that's protected, and you alone is able to determine how that's used, where it's used, and who can use it. Innovation and job creators. Your IP creates opportunities for people that you probably don't even realize, and people that you may never meet. For example, if you're a clothing designer, when you order that wholesale shipment, of whether it's t-shirts, pants, sneakers, like that is creating jobs for the warehouse manufacturers. It's creating jobs for the admins of the website that you're using to place that order. It's creating jobs for the people in the finance department that have to monitor how much money is coming in and how much money is coming out. So your IP really allows for a whole ecosystem of job creations for people outside and within your industry. And also, most importantly, with IP protections, it allows you to continue to innovate, knowing that your IP is protected, and giving you the chance to create more of what it is that you have with that backing that you have, whether it be state protections or private protections. And third, and most importantly, protects public health. Nobody wants to, you want to know that the food that you're getting, the medicine that you're getting, that all of these are from brands that have gone through the regulations and are covered by the guidelines of whatever jurisdiction that they're under. But if you're planning on buying, let's say, medicine from brand A, but it turns out that brand C is actually the brand that you're buying from, but they are pretending to be brand A, this is where IP protections come in because it protects you as the consumer when it comes to just purchasing of goods. So there are four types of intellectual property: patents, which we briefly went over. This intellectual property refers to your inventions. Copyrights. This form of intellectual property falls under creative works, which we'll also touch on in a few slides. Trademarks, which we'll touch on in the next slide. This can cover certain things under copyrights, but many things under copyrights won't be covered under trademarks, and I'll explain that a little later. And the last is trade secrets. And trade secrets specifically applies to information through businesses, information that is important to businesses. So trade secrets could involve your business's pricing model, a recipe that is passed through your family for generations that you are now putting out to the public, that will fall under trade secrets. So anything that has economic value to a business that is not a logo, a physical product of an invention, that's what would fall under trade secrets, which we'll touch on a little bit through the presentation as well. So trademarks. Trademarks, simply put, is any word, phrase, symbol, or design, or a combination of any of these that identifies your goods or services. Scents and colors is something that I didn't know a few years back, but that is also something that can be trademarked. So there's this, for example, there's this company in the US that made Play-Doh, and it has a specific smell and a salty taste. Granted, you're not supposed to eat it, but as kids, you know, they do what they do. But that smell and color, and those smells and colors for Play-Doh, those are trademarked. So there's a wide variety of things that you can trademark. It just depends on what it is that you have and what class that you decide to trademark it in. So goods and services fall under various classes. The classes are different country by country, but you can register a single trademark in multiple classes. So let's say, again, you have a clothing brand, but also within that clothing brand, you're making leather sandals or leather sneakers. Class 25 generally will cover footwear and clothing items. But in class 25, even though it covers footwear, it doesn't cover leather footwear. So you would have to have your trademark registration in class 25 and also class 18 if you wanted to protect your footwear that had leather products. So this is a good thing to this is one of the important things with understanding your brand. Like, what is it that you want to trademark? What classes do all of your products fall under? And planning to see where you should register and maybe where you shouldn't register. Again, you don't have to register everything at once. You could start with class 25 to have those general protections. And then you can also register into a different class as well as time goes on or when you see fit. Certain things that can't be trademarked, generic terms. So I couldn't trademark Apple. I couldn't trademark the term laptop. Government symbols you can't trademark. So government flags, cities, those are things that you generally can't trademark unless you make it into a unique description. So if you had, let's say, the name of a state, but it was in a unique description that was applicable to your business. So, for example, I'm in California. So California Sunshine Oranges. If that is what you wanted to name your company as, if no other company has that descriptive phrase as a trademark, that would be something that you could trademark. Again, when it comes to descriptive terms, attorneys will be able to kind of look at it and provide deeper detail on, okay, even though this is a descriptive term, you might not be able to trademark this because of this country's specific guidelines. Common symbols, that's also something that you can't trademark. So you couldn't trademark like the drawing of a star unless it was a unique drawing of a star. And then it's kind of like those nuances where attorneys get involved on letting you know, okay, this is descriptive enough or it's too generic. And this image below I included because it's really important. When you look at all products, especially products in stores, you'll see either a TM, an R, or an SM. A TM means the trademark is unregistered. That doesn't mean that there aren't protections for that trademark. It just means there isn't a federal registration for those trademarks. The R obviously showing that a trademark is registered, and you can't just put an R in a circle next to any of your products to say you have a registered trademark, mainly for legal implications, but also if you do that, you don't have the protections for that product that you think you have because you don't officially have a registered trademark. And then service trademark, that would just be what you trademark on any of your services that are in products.
Okay, I have a question. Can I trademark
Yes.
my name?
You actually can trademark your name, because you asked me this and I had to double check this. You can trademark your name under special circumstances. So your name, you would have to be using your name for you'd have to be using your name for the sale of products or services. You couldn't just trademark your name for the sake of trademarking your name. There would also have to be, your name would also have to be a unique identifier. So if you were a public figure, you could trademark your name because of the rights that come with that. So if you wanted to have your name LLC, or your name and then co or corporation, like things like that, you would be able to trademark, but your name specifically, it would depend on quite a few factors, but it's something that you can trademark.
Okay, good. Good to know. So
Yes.
someone asked a question, does that mean Apple as a company cannot own the name or label Apple, but with small a?
So Apple, if you see their registration, it is Apple Inc., and it's not just the term Apple, because the term Apple would be generic. But then, yes, so that's where that caveat comes in, where you could have a generic term, but there has to be in addition to that generic term that ultimately makes it not generic. So a company like Apple, yeah, they have a trademark, but it's under Apple Inc. And then there are also designs that they have trademarked under that. So these are more of the stuff like that, which is a good question. Stuff like that is where attorneys will get involved, because someone can make the argument that, no, it's a generic term, you shouldn't be allowed to trademark that. But it depends on what you're using the term for, how you trademark it, and really what type of argument you can place on why you should have that trademark.
Okay. So I'll let you go through this slide. There was another question that was submitted asking, do you have to have a tangible product in itself? Is it possible to protect an idea in itself? Or do you have to have something tangible, a design, an invention to gain IP protection?
So you cannot protect an idea. An idea is the one thing you can't protect, because, and that actually touches into copyrights. If someone's like, oh, I had that idea first, you can have an idea first, but you have to be able to show evidence of ownership. So if I had this idea down, but I wrote it down and I was actively putting in place mechanisms to bring it out from idea to product. You have some IP protections, but the specifics of the IP protections would depend on what it is that you're doing. But for the short answer, no, you cannot protect an idea.
Thank you for that. Okay, I'll let you move on.
So copyrights. This is the right given to authors to control their original works, essentially. So books, movies, artwork, dramatic works like dance, video, and computer software. These are some examples of what you can copyright. What you can't copyright are facts, ideas, systems, and methods of operation. So an idea of like a method of operation, I wouldn't be able to, let's say, if I had a specific way of cutting meat or cutting fruit, you can't copyright that. But now, if you have a specific way of cutting meat or cutting fruit in a way that's unique to your business, that would be protected under trade secrets. So certain things can't be, certain things standalone can't be copyrighted, but depending on the method that you use it, there can be some copyright protections offered under that. And again, I'll say this a lot through the presentation. It's always good to refer to an attorney on kind of the specifics and granular information, because attorneys are going to know how to best interpret the law to help you. You'll see some things where you'll search online and say, oh, can I copyright this? Can I trademark this? And the flat answer would be no, but an attorney will be able to go through case law, go through certain precedents, or also you may be able to find an attorney that is a bit ambitious on going to the new frontier of law and be able to find some protections for you. But generally, these 4 points can't be copyrighted. Dance is an interesting thing because dance is one of those works of art where standalone, it cannot be copyrighted, but a sequence of performances you can copyright. And we've seen certain cases where video game companies have taken dance moves from like an online creator and put it into a video game and then monetize that. Ethically, you can say that's wrong, that's illegal, but legally, they're within their right to do that because there's no copyright on those dance moves. So this is another reason why it's super important because, you know, with Twitter, TikTok, Instagram, when songs come out and people do, you know, the dance challenges and different things of that nature, like though that is your IP, like those are your works of art. And a company with a good legal team can take advantage of that if you don't have the proper IP protections. So these are just some copyright examples. And at the end, if there are any questions on this, because copyrights more so than trademarks apply to a bigger segment of the population from my experience, but we'd be able to touch on this a bit more.
Okay, I have a question. What about logos, like a company logo?
So company logo would fall under trademarks. Company logos would fall under trademarks. You can copyright a company logo as well, but the stronger protection typically will be under trademarking.
Okay, good. Good to know. Thank you. Let's move on.
Yes. And another point, so if you have a trade on the logo part, if you have a trademark for your logo, that trademark protection will not apply to copyright protections of your logo. Just like if you have a copyright protection of your logo, it doesn't apply to trademark protections of your logo. So you'll see, for example, a company like Coca-Cola, for their logo, they'll have both trademark and copyright protections for their logo. So you have the option to go either direction. It just really depends on your short-term business vision or where you intend your business going to if you trademark or copyright or decide to go both routes.
This is good.
Okay. Mm-hmm. And then, so timing for new businesses. When should IP considerations start? This should be a top 3 priority. And why I say this is because your IP is your value and your leverage. How high you value your IP will determine how you approach negotiations, collaborations, and selling your IP in the future. Protecting your IP early allows you to save on future costs. An example of this, without getting into the specifics, but an example of this, let's say you're a clothing company and you start off small, you're selling through Instagram, you're selling through Twitter, but then one of your posts on Twitter goes viral. And then overnight, you have 10,000 orders. You may be able to scale that and be able to fulfill 2,000, 5,000, or even just a few hundred. But your business is now in the spotlight of tens of thousands of people. If there is a counterfeiter that has the means and the funding to take your design and now mass produce your design for cheaper and also sell for cheaper, if you're selling your shirts for $50, they're now selling your shirts for $20. You still have your loyal customer base. But those new customers are going to say, okay, I can either buy this for $50 or I can buy this for $20. The people that decide now to buy that for $20, that's cutting into your margins, that's cutting into your profits. And that's also just generally taking business away from you. To combat that, you would have to send cease and desist letters. If you don't have a trademark protection, you don't have the protections of the government to seek legal remedy for this. So you would either have to rely on word of mouth or rely on the public outcry on like, oh, this is wrong. You shouldn't buy from this counterfeiter. You should buy from the original brand owner. And things like that costs money if you decide to go the legal route. You'd have to pay an attorney to fight it in case, fight the case for you in court. You then now have to go and register that trademark if you want to register that trademark. And that's in the event that the counterfeiter hasn't already now gone and registered that trademark. That's not to say that you can't register your trademark because someone else has. There is trying to remember what it's called. Bad faith filing. So there is a process called bad faith filing where you can prove, okay, this person intentionally filed for this trademark for my brand because of the fact that they saw that my brand was gaining popularity, and here's evidence of that. And you could be successful in that, but again, it costs money to do that. Now, had you had your trademark registered already, your company blows. If there's now a counterfeiter that comes in to try and steal those designs, you have immediate legal recourse to where the cost of seeking a remedy is much lower. And depending on how the case goes, you could be awarded monetary damages. So preparing early definitely saves you a lot on the long run.
And I believe you're going to go through the cost, give us an idea of the cost. So what I'm hearing here is, to the person who asked, when is the best time to start doing copyright and protecting your idea and your brand? what I'm hearing, it's early as soon as possible. Don't wait until you blow, and then
Yes.
the cost, it's a different value at that point. So
Yes. So, for example, it depends where you're registering. So let's say you want to register your trademark in the US. If you're based in the US and have an address in the US, you're able to just register. And the cost of that can be anywhere from a few $100s to a few $1,000s. Again, that depends on how many trademarks you plan on registering and what it is that you want to register. So, and that's where IP planning becomes very important, to know what it is that you want to do, what it is that you can't do, and what it is you want to do in the future. If you're out.
I like that you mentioned IP planning, because we would like to know also, what can I do on my own before I start talking to a lawyer? And
Oh, yes. So that's going to be, so point three, do you need to register your IP? Yes and no. I always recommend, yes, you should, but it depends on what stage you're at in your business, what stage you're at in your business planning, and really what stage you're at with your brand. Um, you have IP protections even if you don't register your IP. The only difference is, if you don't register your IP, you don't have the state protections that would be offered the individual that has their IP registered. So if you're selling clothes through an e-commerce platform, and someone is counterfeiting what you're selling, you do have some protections through that e-commerce platform, in which you can reach out to them, tell them, you can reach out to them through, a lot of them have, um, a lot of them have a system of reporting infringement, whether it's trademark or copyright infringement. And most of the times they do require you to include your trademark registration. But if you don't have your trademark registration, you simply showing proof of use is normally enough to at least get those listings taken down. And while that helps you, a listing coming down doesn't necessarily say that this person isn't just going to go to another site and do the same thing. So this is where the IP registration comes into play, because it covers you across the board in that jurisdiction, not just platform by platform.
good. We have two questions.
Yes.
Like, one is about, what strategies do you recommend for startups with limited budgets to build a strong IP portfolio?
So that, do I have it here? Yes. So that would be under here, choosing the right IP protections. So the first thing you want to consider is, for your startup, what IP does it fall under? Like, if your startup is more in the creative space, you want to look more so at copyrights and trademarks. If your startup is more so in the invention space, you want to look at patents. But at the same time, your startup could fall under different different forms of IP. So it's important to really take a step back first and see, okay, if I'm going into clothing, like, at some point, do I also want to go into clothing manufacturing? At some point, do I want to go into licensing? Um, having these questions and finding out the answers to that is very important, because it'll allow you now to budget for those different sectors of IP. Maybe you need to focus a bit more on the trademark side, and you don't have to focus too much on the patent side until you have everything buttoned down on the trademark side. Or maybe you want to focus on the copyright side and the trademark side, and you're able to do both. And then when it comes time to, okay, I now have to register my logo, register my programs, where do I now do that through? And having those conversations allows you to, when you then bring an attorney into the fold, you have an idea of where it is that you want to go, and they can just provide you the specifics on those areas, but then also provide you a bit of guidance on the future areas that you plan to engage in. Investing in, okay, yeah, so talked about one, two, the short-term and long-term goals, talked a bit about that, but that's super important when it comes to your IP, because your short-term goal with your IP, you may not see what the future of it could potentially be, but being able to just have those hypothetical questions is super important. Like, even if you don't plan on owning a factory to produce your inventions, if I was to own a factory, what would I need in order to get to that point? Having those answers down allows you to just really be prepared for the moment. Prepare for the moment. And when it comes to intellectual property, things are always changing so fast within the space in ways that the laws aren't able to keep up with. So if you're not thinking about what could be, by the time that it does happen, you're now kind of on the back foot, and your business has probably moved in a direction to where, okay, things are going well, but now to get to that next step, it's costing you more, whether it's in manpower and having to dedicate people to think about these things, or you now having to bring in consultants to think about these things, as opposed to just having a foundational idea of where it is that you want to go and kind of generally what protections are afforded to you when getting in that direction.
Great. We have another question, and we know piracy is global. It's everywhere.
Mm-hmm.
It's not one country. So I'm wondering, if you registered in Ghana, for example, do I have to register worldwide or in the US? How does that work?
So it depends on where. If you have a registration in Ghana, that will not cover, that registration does not carry over to the US or states in Europe. I'm not too familiar with China, but well, I'm not too familiar with Asia in general. But
all under any copyright at all? Everything is made in China.
Yeah, and China has really the largest. China is one of the bigger IP issues because there's rampant counterfeiting in that region, mainly because almost everything you see is produced there. So it's a lot easier for counterfeiting to happen there. But they also have some of the strongest IP protections. So it's like a very, it's strange. You'll see most companies, like, they have you have to have a good relationship with China, depending on how far you decide to scale, just to get the protections on certain goods. But to go back to the question, if you wanted to do worldwide trademark registrations, there's no way for you to, there's no really organization where you can register your trademark and it applies, you have trademark protections worldwide. The best that you can do is, if you do have a trademark registration in any given country, that does provide proof of ownership and really just generally evidence on IP enforcement globally. You would still have to register in whichever country you plan on doing business in to get the full scope of IP protections, but you'll have some form of protection. It just depends on which country it is that you're operating in. And of course, some countries, like, if you have a trade, I don't particularly like that this is the case, but like, let's say you have trademark registration in the US, like, your trademark registration in the US will generally be stronger if you try to enforce that in any other country across the globe. So this is another thing that comes with your IP planning, is thinking strategically. Okay, if you're going to heavily invest in registering your trademark, think of where it is that you want to do business in, where your trademark registration um, will be best protected. So if you're in a country where IP protections are pretty loose, or they're not enforced as strongly as you'd like them to be enforced in, then maybe don't prioritize registering your IP in that country. But if there's a country where you plan on doing business in, um, being able to look into what the process is in that country, and the protections that country offers is important, because you could potentially use that registration for enforcement in whichever country you're based in as IP protections. So again, this is where an attorney will come in, because an attorney will be able to let you know, hey, if you register, like, okay, you're based in Ghana, but if you registered in, like, let's say, um, Egypt, like, they have stronger protections, and their protections actually cross over a bit. Like, attorneys based in all these different regions will have in-depth information on, like, which would be the best place to register and which protections you'll likely have in different regions.
Okay.
And that falls into investing into IP protection services. Do you need to? No. Is it a good idea to do so? Yes. But that again depends on what your business is in. If you're in the clothing industry, it's probably helpful to invest in an IP protection service when you scale to the point that you're comfortable in. Um, if you are an up and coming designer, you probably don't need to invest in any IP protection services yet, because you're an up and coming designer. But that doesn't mean you shouldn't know about what resources are available to you.
So question, thank you for answering that question. So someone asked if your brand is stolen abroad, so you've registered locally, but then you found out it was stolen in the US, for example, what do you do?
So that is where you would. So do I have that here? Okay, yes. So that would fall under here, protecting brands and ideas. So skipping through the first two, just to answer the question, that would fall under number three. So monitoring your online presence. Most ways that you would find out that this has happened is through online, or someone sending it to you from what they saw. So you have a few protections under this. Sending in a cease and desist is one option. You can send a cease and desist as an individual, or you can send it through an attorney. There are sites that just offer boilerplate templates for a cease and desist, and you can just add in specific information to it that applies to your case. If a cease and desist is ignored, that is something that you can then take to an attorney, and show, hey, this is my brand. I've been using this logo for X amount of time. I've been selling products through this logo for X amount of time. This other brand is selling the exact same products, is using my logo. I would like them to stop doing so. A few things that the attorney would do is, all right, send a cease and desist as well. Would look into doing an investigation, online investigation or offline investigation, and seeing, okay, when was that brand established? And you're able to kind of find this information online if that brand has registered their business, like hasn't filed a trademark, but has registered their business. There are government services where you could search up that brand and see who the owner is and when that business was registered. So let's say they registered that business in 2016, but you've had your business since 2014, 2013. That's an advantage to you, because you can use that as evidence as, look, I've been using this brand for X amount of time, and they're counterfeiting my brand. Where it gets a bit tricky is, due to the fact that there are different regions, it all depends on the attorney that's arguing on your behalf. because someone could have your same brand name and be 2 continents away and just so happen to be in your same industry. Does that mean they're copying you? No. But if you can find evidence that they're copying you, then you have legal recourse. But let's say they're not copying you, and then they also decided to file a trademark. They have rights to that brand, first use rights to that brand. And I don't want to say there's nothing you can't do about it, but the things that you can do about it would likely have to be done through the courts and cost a ton of money. So when it comes to that, really, one of the first steps is finding out if they're actually copying your brand. And then if you're able to find from your own personal investigation that they're copying your brand, then going the next step to find an attorney, bring all that evidence to an attorney, and have that attorney argue that case on your behalf, either in court or in negotiations with that brand's attorney on, okay, maybe we can change the logo here, and stuff like that. So there are different options, but it all depends on really what it is that you can prove.
So I thank you for that. I want to turn things around a little bit. So we have audiences who are scientists. We have audience who, some of them are parents. We have audience who are students. So let's talk to the student and upcoming innovators. What should they care about? What should they watch out for before they go sign a contract with a company, with Intel, for example, and start making discoveries? Always University of California, UCSF, hospital. So what should we know as students going into, how can we protect our brands and stuff?
So the first thing would be, how highly do you value your brand? That's one of the first things. Like if you're looking to make money quickly, or you're looking to just make a chunk of money up front, then you might be a bit more lax in how you protect your IP. My recommendation is always, like, your IP is your value, your stock. Like, you never want to sell low, you always want to sell high. And with selling high, that's all dependent on how you're able to build your IP and how you view it. So you never want to sign anything without reading through the entire agreement. And some agreements, like, they can be 20 pages, 30 pages, some of them 10, 5. But important sections that you want to pay attention to is the intellectual property sections, and also the use sections. Sometimes the use section will just be termed as IP, or IP termed as use. But those are the sections that you really want to pay attention to. And also, you want to have an attorney review it. But you want to review it before having an attorney look over it, so that you can have the questions ready for the attorney to answer for you, instead of the attorney providing you the interpretation of what it is that they have read, because their interpretation can be 100% correct. But you might see, okay, you're signing an agreement, and you're allowing this company to use your product for the next 10 years. That's pretty straightforward, but a lot of these agreements have legal jargon to where you might not even see where it says, okay, you're allowing them the opportunity to use it for 10 years, but there's also the option to renew this agreement for an additional 5 years. That sounds pretty simple.
Yeah, I like how you're saying negotiate. Don't just jump and sign and because you're overexcited, because now you have a
Yeah, you never want to do that. Negotiating is never bad. And that's something that even with my experience, like I learning till today the power of negotiating. Because a lot of people tend not to negotiate because they think, okay, this is a great opportunity for me. Like they don't approach it as you have leverage in the situation or that your value or you might be undershooting your value. It's always better to overshoot your value than to undershoot it. Like if they come back and they say, no, we don't agree to these terms that you sent, that's fine. Look for a middle ground. But you always want to review that contract in detail when it comes to licensing, collaborating, and even with like the story that you told earlier with the patents, being able to negotiate if I have one patent and a company, I sign an agreement with a company, so where okay, now everything that I create is ownership of that company. I can have ideas that end up spurring like 30, 40 different patents and generates that company millions of dollars. If there's nothing in my agreements where I was like, okay, you have the rights to this, even though anything that I create, you have the rights to this, I have the option to have the patent ownership transferred back to me solely after 10 years, after 15 years, or I have the option to buy back the patent from said company after 10 years, 15 years, 5 years. Um, Things like that is a company is never going to put that into their agreement because look, at the end of the day, everyone is looking for, okay, what is best for me in this situation? I don't want to do you wrong, but what is the best for me in this situation? So you have to value your IP in such that, okay, even if this party benefits from it, I still have the opportunity to benefit from this in the future. But if you just sign an agreement and they took one patent and now they have 30 patents and
Right.
technically you are the person that created those inventions, but you don't reap any of the benefits from that. That's all coming from the agreements that you sign and your intellectual property. So
Yeah.
being able to review that and negotiate is super important, especially in today where, it's a lot easier. There are a lot of tools to our dispersal where we can create whatever it is that you want to create. Like there was a time where if you wanted to be a coder, you know, you had to go to school or you had to like seek advice from someone who was actually into coding. And where today you can just do a Google search and you can find tons of coding resources, free resources, low cost free resources to where you can learn to become a coder and end up developing a program that you can trademark or end up developing a program that a company wants to acquire. And with that, that's your IP. You want to protect that and you want to keep it to yourself for as long as possible while still being able to reap the benefits if you license it or sell it.
Okay, I thank you for saying that. So there's a question here. What if the company refuses to pay you for a product you developed? What can you do?
So that all depends on like what you agree to. So within the agreement, if you agree to, okay, like I'm developing product A and I will be receiving payment for product A, but I will also be receiving royalties for product A, then legally you're fine. You get an attorney and they work it out and you get that payment. But now let's say you agree to, okay, if you develop product A, we're paying you $5,000 for product A. And they use product A, and product A generates $20 million for this company. You're then not, and I'm using these numbers mainly to just stress how important your IP is because you never know how much taken out of the monetary sense, you never know how highly valued your IP is and what it can then develop into. So if you mentally don't look at your IP as being able to generate thousands, millions of dollars, then you won't protect it and such, or you won't negotiate for it as such. If you think that, okay, this is just a good opportunity for me, you're just going to take whatever it is that you can get from this. You can still do that and you're within your right to doing that. But in the event that what you've now sold off generates 10x, 5x, 10x what you were paid for, you can't now go back and say, okay, actually, you underpaid me for this. I want this. What you agree to is what you agree to. So, what you're entitled to is what you can negotiate for at the end of the day. And if they refuse your negotiations, they refuse your negotiations. And then at that point, you have to make a decision. Okay, are you willing to now take what it is that they're offering, or are you willing to walk away from the table? And if you walk away from the table, like what you have is what you have at what it is that you valued it at. And so being able to understand the risks that you're taking and knowing what it is that you're comfortable walking away from and what it is that you're comfortable accepting is very important when it comes to the negotiating table with your IP.
This is very good information. Thank you for that, Ike. So I'm hearing that if you work for an employer, typically the intellectual property language that I've seen is the employer tells you, once we hire you, once you're working for us, anything you discover, you invent here during our time. Some may even add maybe 10 years after a window post you leaving the company that it's owned by the company. So it's very powerful to read the contract, read what you're signing, and negotiate well.
Yeah. Yeah. And another thing is with just my tip generally, if you are working at a company and you're working on something else that is not applicable to that company, do not use company resources to create your IP, because legally, the argument could be made that the company owns that IP because of the fact that you're using company resources and company time to develop that product that is not for the company, but for yourself, especially if it's something that is in the same competitive market as the company that you're currently employed by. So when it comes to company issued laptop, company issued iPad, company issued tablet, being on company property and using any of their resources, if you're going to do that, understand the risks that what you create could end up being that company's intellectual property because you're using their resources to do it. And this is also why it's important to read these agreements, read the NDAs that you sign, because that language will be included in there. And if it's not included in there, it's a good thing to ask. Like, hey, if this is created, like, what does this fall under with your IP policies? Would it still be mine? Would it be the company's? Like, these are important things to ask, because saying you didn't know isn't a strong enough argument that ever flies in court or flies with any of these companies, especially if what you developed turns out to be extremely useful. So that's another thing to just be very wary of. And the same with platforms. Like if in one of my other slides where we touch a bit on the AI, like if you're using a platform to, let's say, design your logo or put designs on a t-shirt, or even develop a program, like going through that company's terms of use and seeing, okay, what are the IP protections? Like if I create this design on this software, is the software company the owner of my IP? Do they have rights in licensing my IP? Am I able to register my IP because it was made on this? So it's important to go through those terms of use, especially when you're creating on all of these different platforms.
So this is very good information. Don't use companies' laptop or resources for your innovations, even if it's not related to what you were hired for. That's very good information. So what about students who are with a school and say for in your project, you developed a product? Who should file for protection? In this case, the student or the school, or both?
Schools are generally not for profit, so you're pretty much safe when it comes to if you were on campus and you were developing something on campus. Um, Generally, that IP is yours, but again, it varies. So, like, let's say you're a robotics startup and you're using the robotics lab on a university campus. My recommendation would be to get guidance on, will this IP be mine for me using campus resources? But let's say you're a high school student and you're using your high school computer lab or your high school's lab to do this. I would still have the same advice to check in and see, okay, will this be mine if I register it, or if because I'm using school resources, does the school play a part in that? I haven't seen any cases where that has happened with like high school, middle school, and below. With college campuses, it can get a bit tricky because some college campuses do operate for profit, like medical centers and stuff like that. So
Yes.
if you develop a crazy invention that assists in surgery on a university's campus, the university would probably want some form of stake in that, I would imagine. So that's where it's important to, again, with forecasting your IP plans on your startup, on your business, on your brand. These are the type of questions that you would then bring to an attorney, or even before bringing to an attorney, you can just bring to the school, the company, and ask, because they're legally required to provide you with that information. They can't charge you to then, give that information. But if they give you that information and it doesn't make any sense, or it seems like they're giving you the runaround, or it's like a word salad, then you bring in an attorney to like really give you the details on, okay, this is exactly what you can do, what you can't do, etc.
This is great. This is great. So before we get into NDAs, because that's also critical, what would you say to parents of young children? So I gave you that example when my kids were little, like 2-year-old, they would draw their arts. And to one person, it may look like Jaga Jaga, but I always tell them, put your name on it. So what message would you say to parents to sow the seeds into their children so that they are aware of what to protect and going forward?
With artwork, tell your kids to sign their artwork with their name, a signature, and a date at the end. And I say that because little things like that, especially early on, kind of teach you the importance of ownership as you move forward in life. So one of the examples is like, let's say your kid in art class and they make something and everyone's like, wow, this is amazing. And then like a teacher or another parent, it's like, oh, I'll buy this from you for $5. Like, that's great. Like, oh, now I have $5. But now what if instead of your child saying, yeah, I'll take it for $5, they say, no, okay, you can give me $5, but you can only have it for 2 weeks or 3 weeks or a month, and then you have to give it back. Something as simple as that is teaching your child about licensing their work without having to go into all the specifics of licensing. But that kind of sparks that interest in, okay, this is something that I can do. Like when I'm now in high school and my artwork is more refined, and maybe a brand wants to use my artwork um, for a showcase that they have or a campaign that they have. You have that understanding from like at age 5, yeah, I licensed this picture that I made in art class to a parent. Now you know, okay, like I have to license this to a business. I'm not just going to sell you my design. So something as simple as that, just speaking to your kids on that. Also, definitely. And this is more just a general tip, not having your kids sign like any type of like agreements or anything like that without you like reading over it. And when you read over it, have someone else read over it. Like there's no harm in triple checking anything that's being signed, even if it's just a one page document. Because with doing that, you're teaching them to kind of to identify general things that make sense and also identify something that doesn't make sense to them or something that's new and okay, now I need to seek guidance on this. So those are like the three things I would say because it applies to a of wider range of topics. Like it's not just specific to artwork. It could also be specific to song. It could be specific to dance. Like, oh, can you teach me how to do this dance move? Okay, sure, I'm going to record it and then sell it to you. And this isn't to say, I'm not saying, okay, you teach kids like, oh, everything you have to sell, you have to sell. But
The evil
it's
man.
teaching, it's
She,
teaching that everything that you have has value.
right.
And even if it's for free, there's still value attached to it. And you should be cognizant of all the options that you have. Don't think that you only have one option. Think that you have 4 different options. And if 3 of those options don't apply, then yeah, go with that single option. But
I
in
like
that scenario where you want to maybe do something else, you understand that you have the ability to do that. Now taking it there.
that. This is great. And I know we're going to wrap up soon, but now let's talk about NDAs, non disclosure agreement. Some people call it CDAs,
Yeah.
confidentiality agreement. Please talk to us about it because when you talked earlier and said it depends on what you agreed to with your employer or with the school, it's not agreement by verbal, like, okay,
Yeah.
it's reaching down somewhere. So
Mhm.
tell us more about NDAs and CDAs, please.
So the NDAs and CDAs are important, especially when it comes to the trade secrets side of things. Like if you're a startup, NDAs are super important because your your trade secrets is really that's like the lifeblood of your business. So NDAs are important both with employees, people that you're bringing onto your team, and also when you're working on collaborations and just having discussions with other people within your sphere of business and competitors. So with the NDAs, this is just like, okay, if we're thinking of collaborating with this business, it's not official, but we're thinking about it. Being able to have that discussion to where it's like, okay, we're having this discussion. The information that will be presented in this discussion is privileged information and it cannot be shared, reproduced, or disseminated for a period of 5 years, 10 years, however many years that you put on your NDA. This allows so even if you're having discussions with a competitor, if the collaboration doesn't go through, they can't take parts of what was discussed and now apply it to their business, forming unfair competition. Also with hiring members onto your team, people that join startups, they don't always stay at that startup, and sometimes they leave and have their own startups. So you want to make sure that information that they're leaving with, they're not now leaving with to put into their newly found startup and add unfair competition as well. So NDAs are super important, because it just allows you to have these conversations a bit more freely without the worry of what you're saying or what you're sharing being used against you from a business standpoint. NDAs generally do that type of coverage, but from a business standpoint, keeping individuals from using this in what it is that they want to do in the future.
Okay, this is great. Thank you for that information about NDAs. We have a few more questions coming. This is really good.
Okay.
If you have any additional questions, feel free to pop them in the Q&A or the chat. So first of all, Lisa asks, what if you were asked to write a paper on a particular subject and then your work is used by the school, but you were not given credit for that? What do you do?
Well, I guess it would depend on the context. So like, let's say it was an assignment that was given to you and then the school wants to use it. Do you have protections for that? Generally, no. Let's say it's something that the school was then using in a competition, like a competition with monetary gain, or they were using this, they were selling this on their site. If they're using it for sale, then the discussion has to come in as to what is the terms of use for this. Like, is it anything that I create is technically property of the school, or is this something that I can now use on my own? I don't want to say it wouldn't necessarily fall under plagiarism, but that would be a conversation to then have with the school, because you can't initially have rights protections, but you would have rights protections if the school is claiming it to be as their own. So let's say you write it and then they remove your name from it, and then they just presented it as something that the school put out. You would have some recourse in that. The recourse that you would have, I'm unfamiliar with, but that would be what you would just discuss with the school, whether it's providing that they put your name on to say, okay, this was actually the works of such and such, or if they've been gaining money from it, having discussion on, okay, what is rightfully due to me, being that you took my work, removed my name, and then repackaged it and sold it as yours.
I like that. That's a great information to have a discussion with the school. I remember when I was a student, research student, postgraduate student, and whenever we write a paper, publish a paper, my professor will add my name, his name, and whoever else worked on that project for that publication. And that's the right thing to do.
Yeah.
So I think it's definitely worth having a discussion with the school. Like, why did you remove my name from it? Or make a demand also that I would like to have my name on that because I work.
Yeah, and yes, and that's really the important thing. Like, if anything is taken from this presentation, really, like, the important thing is understanding that your IP is valuable. Even if you don't see the value in your IP, someone else may see the value in your IP. And if they see it before you do, they may be able to just take advantage of that. And then you might not know until it's too late. So valuing your IP to where, if you're going to write a paper, like, simply asking, say, hey, like, if I write this, do I have ownership for this, or do you have ownership of it? Even something as unofficial as that lets the person know, okay, this person is thinking about their work a little differently. And if hopefully this isn't the case, but let's say they did have intentions of using this, gives them a pause, and then based on their answer, will kind of give you guidance on, okay, I might have to look at this a bit deeper, or okay, this is fine for me to go ahead with, or I need to ask more questions.
Okay, great. One final question here, then we'll go into the resources and how people takeaways for people. So there's a question here. Can somebody acquire IP rights for a t-shirt with a phrase like free Israeli hostages?
Yes and no. So I'm going to lean more on the no side because that's not a generic term. And I mean, sorry, because that is a generic term. And it's mainly a generic term because of it might not have been a generic term a year ago, 2 years ago, 3 years ago, but due to the popularity of it, it's not something you could just outright trademark. And if you are allowed to, this is where an attorney would come in because it would also depend on where you're looking to trademark that phrase. I would like to say politics doesn't apply to these things, but politics applies to everything. So it might not be because one thing you can't trademark are derogatory terms. And on its face, that isn't a derogatory term, but to someone that may be a derogatory term, to a group of people that may be a derogatory term. So then it comes to the attorneys to be able to argue to the trademark reviewers why something may not be derogatory or why something may be derogatory or um, why something isn't descriptive enough or why something is too generic. So there are a lot of factors that come into when you're trademarking specifically phrases and words. Like it depends what it is that you're looking to do, the time that you're looking to do it. So what is the climate in which you're looking to do it in? But that's something specifically that an attorney would be able to answer for you.
Great, thank you for that. Do you have anything to say with regards to using AI now and intellectual property?
Yes. So just quickly touching on this, AI, tremendous good, but also a lot of harm. Like counterfeiters use AI all the time, from scrubbing social media platforms to see what are the most trending topics and then narrowing that down to, okay, what are the trending designs on Twitter right now? Like AI can be used for tons of things. In the court system currently, in the US court system, there are quite a few cases involving AI models using images, phrases, creators, works of arts, and generative AI models. So the AI models that produce word phrases, that produce pictures, and that all of that information is taken from somewhere. So there are a lot of court cases right now as to, okay, how is this regulated? Like if I had a drawing on the internet and now this AI model is using that drawing as a foundation to create other drawings based on prompts people use, is that breach of my copyright protections? And those are some cases that are currently working through the courts now, to where whatever decision is made, that will kind of start to form the building blocks on how AI and IP is currently regulated. While that's happening, some proactive ways that you can go about protecting your IP is, like I mentioned earlier, reviewing the terms and conditions for all these platforms that you're creating your works on. So if you're using an AI model to, let's say, create artwork, or you're using an AI model to create different forms of code, looking through those terms and conditions and seeing okay, if I create it on this platform, do I own what I create? Does that platform own what I'm creating? Do they have partial ownership of what I'm creating? It's important to review those so you can decide how heavily you want to rely on this platform for what it is that you're doing. Um, and also just monitoring the latest news. You can just do a Google search and simply say, provide me, or you could even use AI and say, provide me with the latest news on copyright cases involving AI and cite 20 sources and be able to see what the most up to date news is on those cases. So you know what protections that you do have or what protections that you don't have in the industry of your work. Um, and I'm not an AI expert. I do use AI heavily in my everyday work. But when it comes to IP, it's still very much a very new frontier. So being up to date on that is very important, especially for anyone that's in the startup industry involving technology, anyone that is in the digital art industry. AI, understanding how AI affects you is very important. And a few ways to start is just seeing the news and reviewing those terms and conditions. Very important.
This is great. Thank you so much for what you've shared. We've learned a lot. So yes, let's.
Yes. And then I already touched on a lot of this through and through. But just to briefly go, it's never too early to protect your brand. Always think of ways that you can protect your brand. Um, Reviewing contracts, review your contract, and then have an attorney review your contract. Review your contract, have questions, have the attorney review it, and have questions for that attorney. Um, have an IP strategy and records management. If you choose not to register your IP because of costs, that's fine. But have a record management system to where you can pinpoint, okay, this was the day that I started using this mark. This is the day that I started using this mark on such and such platform. Being able to have records on your use of this is important because you can use that as evidence to gain some IP protections, even if you don't have a registered trademark. Um, Not budgeting for IP protection is always one of the biggest mistakes. For example, if you know that you want to get into clothing and you want to register your trademark within the next 4 years, and the cost to register in class 25 is $325, take out, whether it's monthly or yearly, a portion and set that aside specifically for your IP registration. Even if you end up not registering your IP, that money put aside can be used for, okay, if you want to, let's say on eBay, see who might be using your design for your t-shirts or for your sneakers, you can reach out to an AI, I say AI, you can reach out to a IP protection agency and have them scrub the site for you. And whatever the cost of that is, you've already set aside a budget to account for that, which can let you know if you need to register your mark or if you don't need to register your mark. Not educating your team is also a very common mistake. You want to have everyone on your team having a general understanding of intellectual property, especially when it comes to use of your logo, use of speaking on behalf of your brand in different conferences or scenarios and things like that. You want your team to have an understanding of your IP and knowing that, don't just slap your logo onto whatever personal work it is that they're doing or slap your logo onto slap your logo with a bunch of other companies on a flyer or something like that. Little things like that prevent issues in the future, especially with other brands from coming after you for saying, hey, you put your logo on this flyer that also had my brand's logo, but we have no form of collaboration, like that could cause legal issues. So making sure your team is educated on the generals of IP, what to do, what not to do, is also very important. And last slide, I included these resources. These are 3 government public resources that anyone could go on to. And these resources will have details on really the processes of IP protections. It'll have a breakdown of all of the trademark classes, copyright classes, and patent classes for you to see what exactly your business brand falls under. And also just has news relating to what's going on in IP globally. So the World Intellectual Property Organization, this portal is one of the portals that allows you to file trademarks in different countries in one space. Like let's say you wanted to file in Europe, it's through the Madrid Protocol, which is all featured on the website, and that allows you to file for individual trademarks in different countries under one filing. U.S. Patent and Trademark Office, you'll have all the information on patents, trademarks, their classes, public resources on attorneys, as well as non-government organizations that provide further free resources for you to look through, and even just include in slide decks for your team to look through and have a general understanding. And the Nigerian Industrial Property Office, which has all of the information, all the IP related information when it comes to registering your mark with the registration office.
These are great resources. Okay, so thank you for that, Ike. This was helpful. So there's one more resource that I want to give us to take away, and that's the IDEAS website. That's IDIYAS. It sounds like ideas, but it's IDEAS. It's more global. It's not restricted to one country. So I'd like to share that takeaway so we can know how to search for your name, your country, and see how many, I'm sharing my screen, and seeing how many, this is not the one. So, okay, here. So I could type here, for example, I'll type Okolo and see how many patents. So this will tell you how many patents. This is a very good website to save. And we can put that in the chat. Someone can put that in the chat. It's ideas.com. So it tells you how many IPs are registered under this name. And the beauty of this is you don't have to know the first name. Once you have just the last name or part of it, it will start telling you which countries. There are different countries that have this last name, Okolo, on IP. Let me try another. I'm going to try another last name before I try Mr. Uzo's name. See, for example, we have Faleti. It tells us the country where the patent is registered. Let's see what that is. Yeah, so if you click on that, it takes you in and gives you more detail what it is, who are the collaborators and stuff. So I want to type a country. I will type, for example, Nigeria and see what comes up. There's one under Chevron. That's interesting. Let's try Kenya. There oh, those are names, more like the country, place. There are 200 IP recorded under. It also tells you universities. Interesting. Let me type Stanford. So I see 8 under Stanford. I will expect more than that, but I guess people want it under there. Oh, Stanford, the city of Stanford has much more. So this is a good website for reference. When I put Mr. Uzo, he keeps growing, 382 IPs in his name, and it will tell you who are the other inventors and collaborators. So this is a good website to hold on to do a search and see what's available. And it will also show you the comparison for different countries and who has the most. I believe the US has the most. And of course, we have people from all over the world who are in the US who have contributed to those numbers. So ideas.com is a good one to take away. Right, I will stop sharing. All right, so we've come to the end of this meeting. It's been highly incentive and educating. I really appreciate everyone's interaction, the questions that came. We will send you a feedback afterwards, like a follow-up, and just let us know how this went. It will also it's recorded. We will also share with everyone who registered the recording. So I want to thank Ikechukwu Onwukanjo. Thank you so much for educating us, taking the time today on your Saturday to share this with us. And to everyone who took the time to join from various places, we say thank you so very much. We hope you've learned something. At least, at minimum, you're aware what IP is and how you can protect your ideas, that you have valuable idea. Remember, those companies like Google, Tesla, UPS, FedEx, Amazon, they did not wait until they blew to record and protect their brand. You have a brand and it has value. You may not know it now, you may not show it, but believe in yourself. But now you have options and you know what to do with it. So before you sign a contract for your future innovations, read it well and be well informed. What's the final takeaway from you, Ike? We'll wrap up.
My final takeaway, honestly, is just value your IP heavily. I can't stress enough how important it is for you to just have high value in your IP. I looked at a couple of the questions under the Q&A, and I'm going to stay away from the patent, AI, or blockchain because I have too little experience in that to offer any type of guidance. But the second question, when it comes to critical decisions to consider, and this is just a general tip, consider the market that you're registering in, the IP protections afforded in that market. Different countries have different protections. Some are stronger, some are weaker. So that's a big thing to consider. Consider the filing fees and the maintenance fees. Just because you file for a trademark doesn't mean that you have it forever. The average trademark registration is 10 years. Some countries it can vary, but the average mark is 10 years. So that's one thing to consider. How much will you have to invest into maintaining this? Competitors, that's another tip to consider. If you have a patent and you want to register this, like in the US, for example, what is the competitive market and what it is that I'm doing? Who are the main players? Am I comfortable competing in the environment with the main players? I feel like everyone should be comfortable competing with anyone. You should always bet on yourself, but these are things to consider. And really it's never too early to think about your IP. You don't have to be $1 million business to think about your IP. You can simply just have an idea of what it is that you want to do. using myself for an example, I have never viewed myself as being an entrepreneur. I was always like, when I was younger, I was like, yeah, I'm going to work in corporate America, and that's like what I want to do. But over the years, my mindset shifted a bit on, okay, I have skills that I can maybe be entrepreneurial about. And I'm in the process of, I've already started my IP forecasting and planning without even having put out a product. So it's never too early to start thinking about these things. It actually allows you to think a lot bigger about your brand. It allows you to think about the things that you can get into. Like one of the companies that was just mentioned, UPS, like UPS was started with $100 between four people about 100 and so years ago. Granted, $100 back then was a lot of money, but to put into context, if you see UPS now, you can see just the color scheme of the logo without the words UPS, and you can automatically associate that to UPS. And that could be said with tons of companies. Apple, you don't need to see Apple for you to know it's Apple. You see that logo and you know exactly what that company is. When people ask you to search for something, like most times someone will say, oh, just Google it. But you could be using a search engine that is not Google. But this is all IP. And this is all spurred from people that thought of their IP early on. And as their business grew, their IP strategy, IP ambitions grew as well, as to where you can no longer, you want to get to a point where your brand is associated to you. Like it can't be confused with anyone else. It can't be confused with anything else that you do. Like your brand is associated to you. So having that type of value to it and just understanding that importance. It's one thing that I hope you all take from this. And I'm also available for you to ask me like any type of questions. I don't typically use LinkedIn, but if you email me, I'll answer. And like I'm always on my email. There are tons of people that I know in the intellectual property space, from attorneys to creatives to people even in the brand enforcement space, where, you know, if there's a question that you have that I don't know, chances are I know someone who either has the answer or they know someone that has the answer, and I can help you with that. So these are all free resources. Like I'm about spreading information. A lot of this stuff like you can get from attorneys, but attorneys will charge you. So if there's any way that I can help, I can be a resource. I can leverage my resources to be a resource for you all. I'm 100% available for that, and more than happy to help how I can.
Thank you very much, Ike. We also spoke with one IP law firm that's based in Nigeria and the US. So if anybody needs that information, you're curious, let us know, have the conversation. So we've been well educated today, and I hope that we will no longer say, I did not know what IP is.
Yes, that should no longer be an excuse. Tell your friends about IP. Tell like it's that doesn't hold as an excuse anymore. And that excuse could be something that costs you like dearly in the long run. So it's better to have the information and just not be using it than, well, it's better to have the information and plan to use it than not have the information when it's just here readily available for you.
Thank you. On this note, thank you for joining this Values of Affordable Education webinar. We hope to bring you more valuable information. Keep spreading the word, keep spreading the light, and we'll talk to you next time. Goodbye, everyone.
Bye, everyone.